This is lecture 3 for registration, means lecture 3 of industrial design. So rights of registered proprietor, copyright in registered design. It is design, but language is copyright in registered design, and for infringement it's piracy. Okay. Section 11 says registered proprietor of a design has copyright in the design. Copyright means exclusive right to apply a design to any article in any class in which design is registered, meaning thereby when you apply a particular design and you apply it on particular article in particular class. Okay, so you have exclusive right to do that. Then right to institute a suit for injunction, section 22. Registered proprietor can institute suit for injunction, okay, as well as recovery of damages. These are the remedies, recovery of damages against any person engaged in piracy of the design. Piracy means infringement. Without your permission, they are using it. Okay. Then a registered design shall have all effect as against government, as against any person. Meaning thereby, unlike patents, where government can use patent for its purpose. Okay, government can use patent for its purpose in copyright and patents, compulsory license is there. But when it comes to design, such things are not there. So provision of Copyright Act to apply on design. This is section 15. Little bit of hint I gave you in first lecture. So copyright shall not subsist under Copyright Act in any design which is registered under Design Act. This is first thing. If your work is your design is registered under Design Act, then you will not get copyright protection. Design can be registered under Design Act, but you have not got it registered. Okay, so you will enjoy copyright protection. Okay, as long as you do not manufacture the article through industrial process for more than 50 times. When it goes to 51 times, your copyright protection ceases, and you have not taken design protection, so design will also cease. Once the limit is crossed, it will lose its copyright under the Copyright Act, and you cannot get it protected under design because it will be disclosed to public. Or any other reason, technical reason may be there. If we get some from jurisprudence of court, we'll see to it. What constitute infringement? Section 22. Any person other than proprietor. Okay, proprietor means owner of the note mark, owner of this design. Okay, if any person other than him apply or cause to be applied the design to any article in any class, okay, for which it is registered. Apply or cause to be applied design in class for which it is registered. Fraudulent or obvious imitation of the design. Okay, or to do anything for the purpose of sale without the consent or license, written consent or license of the proprietor. To import for the purpose of sale without the consent of registered proprietor. So you cannot apply it on article and goods classes for which it is registered. You cannot make fraudulent or obvious imitation, and you cannot import. Having applied to the design or any fraudulent or obvious imitation thereof for the purpose of import, you cannot do it. To publish or expose or cause to be published or exposed for sale. If it is done by any other person who is not authorized, then it constitutes infringement. Then to imitate, to initiate an infringement action, what should be there? First, that copyright in design subsists, means it is registered design. Then pirated article is fraudulent and obvious imitation. Okay. The design applied on pirated article is without written consent. And piracy has been done for the purpose of sale, import or publishing. These requirements, which also comes in section 22, are to be fulfilled. Then particularly fraudulent or obvious, what does it mean? So fraudulent means knowledge and intention to cause confusion and deception, okay, for unlawful gain. Now this confusion and deception is not mandatory. Similarity is much required, okay. So obviously when things are similar, then there will be confusion and deception, but you need not to prove confusion and deception. Similarity is required to be proved. So fraudulent, obviously deliberate action. Internal rubber, okay. Imitation perceivable when the two designs are closely scanned. You need to scan two designs closely, then you can differentiate or bring the similarity, and then you will find it. For establishing piracy, imitation must be established. Imitation must be established, and that can be checked judging eye of the consumer. Okay, so imitation must be established that yes, he has imitated, and imitation ought to be substantial. Ought to be substantial. Substantial similarity to the genuine article is required. Okay. Now, you can debate that it should be substantial in the sense when a minor feature may bring substantial similarity or differentiation, that will prevail in the background. But altogether it will come to be substantial and substantial similarity. Okay. Obvious means something which as soon as you look, strike once at once as being so like to the original design. The moment you see it, you will think that this is the original design. Okay, unmistakably look like original design in the first sight. Obvious imitation is something which is very close to original. These are just another words to say the same thing. Dabur India case, court said that similarity need not to be necessary to be exact, but test is of substantial similarity, which I already told you. Imitation does not mean duplication. Okay, it is duplication, then it will be exact replica. So it need not to be exact replica. Substantial similarity is there. Is the requirement. If substantial similarity is there, that will work. And it is not necessary to prove confusion or deception. If it is similar, automatically it will be there, but you need not to establish this as an independent in trademark. You need to prove this as an independent, criteria. If design is registered in 2D, representation of same in 3D would constitute infringement. Then remedies, section 22, person is liable to pay rupees 25,000 for every contravention as a contract debt. However, this sum total of infringement of one design shall not exceed 50,000. If proprietary act to go for injunction also. Okay, so injunction and damages are the two remedy, and 25,000 and then 50,000 is the limit. This is just a limit. Okay. If you go for injunction, if you go for damages, then court can award any damages. This is not to restrict damages. Okay, it will be different. And assessment of damages, it depends upon various factors: conduct of defendant, royalty plaintiff receiving from others, quantum of infringing goods, and other things, other similar things. So this we have already done. This is there. Defense available. Okay. So defendant can raise every ground, including cancellation. That is, registered design should be cancelled. And court is empowered to pass judgment that the already registered design is invalid. Okay, or it may uphold its validity also, as the case may be. So every decree which is passed by court in a suit for injunction and damages, it will be sent to control. In all IP it's same, because he has to make necessary variations in the register, in the record which they have with them. So action for groundless threat. If groundless threats are there, that will proceed legal action against you and your design is already different. Then you can go for groundless threat. You will say that this person is sending me groundless threat of legal proceeding, although my design is very much new and original, it's different. And you can get a declaratory decree also from court. So section 106 of patent also talks about similar thing. That's why I mentioned it here. It's from intellectual property only. Then this Carlsberg-Brewery's case. Okay, this was the case of bottle. Hunter is Carlsberg. Then this Som Breweries. This is the bottle to bottle. This was the registered by this Tuborg is Carlsberg, and then Hunter is Som Distilleries. So Tuborg is Carlsberg. So court said that this is the bottle and they wanted protection for full shape of the bottle. They did not mention any specific feature. Any specific feature. They said novelty resides in this bottle. Registrar gave protection. Defendant started using this bottle. So court said this Carlsberg initiated infringement case that they are infringing. So they defendant contested that registration of this Tuborg is invalid in itself. So court said, look, this is the defendant bottle, this is the registration of the design, this is the shape which is applied to article. Through this you can understand this also. This is the shape which applied to the article, different from manufacture. You can understand through this example also. Now coming back, excuse me, these are other bottles available in the market. So court said if you see all these bottle and you are asking registration in full bottle, no particular feature, then this is nothing. This is Tuborg is nothing but another bottle. That's all. So there is no protection. There is no protection. So you can read this. What I have told you, it will be there. Plaintiff says it's an imitation. Defendant said when compared to previous bottles, there was no novelty. When compared to no novelty or originality in registered design. Yes, we can see that also. Court also relied on the judgment of Castrol that functional shape and configuration dictated solely by functionality are not registrable, obviously. So the functional nature is that you can hold the bottle properly and you can use it. So all these are for those purpose, and this just another bottle, nothing new, no new shape, no differences there. So court said that there has to be novelty and originality. Okay. Novelty must be potent to ensure that entire design is distinct or dissimilar from previous designs. Now they might have asked for protection for particular features. Then they might have got protection. But it is the drafting which I told you in first lecture also, previous video. Plaintiff design registration claim novelty in entire bottle, not in respect of any part of it. Okay. The statement of novelty in design certificate, novelty resides in shape and configuration of the bottle. So court said that this bottle is in itself not new and original. It is just like other bottle available in prior art, so no protection. Then court said defendant's bottle does not appear to be fraudulent or obvious imitation. Okay. They both appear to be ordinary bottles, like one available in market. That's all. So emphasis was the statement of novelty to determine novelty and original aspect of the design, which I told you earlier. So we can do one more case study here. It's about helmets, Roha versus Stud. You can find the case also. It's available. The plaintiff product is helmet bearing novel and distinctive feature in shape, configuration, surface pattern. Okay, so they got it registered for shape, configuration, and surface pattern of the helmet. And this plaintiff marketed it. Okay, then later on they got to know that this design number is similar. They found that this is fraudulent imitation by defendant. Okay, format in same design. Okay, fine. So plaintiff representative visited a shop and they purchased the defendant's product. Okay, and then they also compared it. They do these things to to have evidence and to check by themselves also. So they compare and they found that. So from this comparison, no difference was found. This is you will get to know after the case, but let's see their contentions also. So defendant said that plaintiff, the design of plaintiff, it falls in section 4 as it lacks novelty. Section 4 requires design if novel and original can be protected. So defendant said it's not novel, not original. Okay. So the novelty is claimed this beak-shaped design. I'll show you. Look, this is already existing one design. Then this is another starts. Then these are the beak-shaped designs. Okay. And these are other than from plaintiff and defendant, which are already existing in the market. Then these are some other designs. So basically it was beak-shaped design, and codes for the reference produced other designs also, what are there in market. Okay, so it was contested that no novelty reside in beak shape helmet because prior designs has already having this, okay, this beak shape. So this is Sturz and Arioha and other players are also with beak shape. Rate card catalog of these helmets were available at the time prior to the registration of plaintiff design. So how it brings novelty and originality if already existing. And there is no similarity between plaintiff and defendant helmet as told you in the first slide also. So then it was contested that this visor at the center of helmet, visor has a functional feature, obviously. It is a common to trade and also, uh, functional feature cannot be protected. Visor, what is the purpose? To give good visibility and good water runoff. Apart from protecting the eyes, okay, these are the, some minor functional features. So for this, how many, design and shape you can come with? Nothing much. So no novelty and originality resides in this. So plaintiff said that defendant failed to produce the documentary evidences. Okay, that helmets were pre-published before plaintiff's design, and then defendant were aware that plaintiff's helmets are already in the market. So, but defendant is saying that plaintiff's registration is altogether invalid. So court said that, pattern of helmets are available in the country and other world also. Okay, these patterns beak shaped are already there. Even plaintiff is manufacturing and marketing helmet for last more than 20 years. Issue is that whether novelty, shape and configuration claimed by plaintiff during course of hearing is new and not been published prior. So court said that we do not agree with the plaintiff's contention. It is already there. If it is common trade practice that a shoe should not have spikes attached to sole, if someone attached sole, then it is not a design but a trade variant. This is one example. So it's a trade variant, it's not a design, it's not something new. It's a minor functional feature. Okay, shoe with spikes. So this novelty has to be adjusted by the, layman's eye test. Novelty, the eye is to be the ultimate test, and determination has to be of normal ocular impression. No expert view is required. So court found that similar designs were in fact already available in the market. And it is also a matter of fact that plaintiff has not taken any action against the company who is marketing Sturz and Areha. Plaintiff has never won against them. So the mere glance at the product of the plaintiff reveals many similarities. Yes. Plaintiff's product is not dissimilar from designs of these two companies already existing. Okay, beak shape are already there. This is most important thing. Even otherwise, the addition of small feature here or there from the features, design would not make any difference. And it will be a routine trade variation. That's all. This is the crux. This is very important. As I told you, it should appeal to eye. It should not be only a visual thing. It should appeal. So here and there, small additional feature will not give you originality. It will be a trade variant as per the demand of customer. That's all. Now the similarities which were there in prior published helmet and steelbird helmet was not much debated. Okay, sometimes small and trivial changes gives new feature to shape pattern which can be judged by consumer, but court did not went on. This is case of steelbird helmet. Okay, steelbird helmet. If you just you can find it available. It's an important case also, but court did not discuss it, because if you see then you can also find it. It's very journal also. So this is just repetition. So the case is this this Steelbird High Tech India Limited SPS Gambhir. Okay, matter happened in 2014, and then they had another case against Asia Fiberglass. This was in 2020. These two cases. So this SPS Gambhir and others, this is the case study which we have done. So if you have any question, query, you can put that in comment box. Thank you.